Welcome again. We're going to be talking about medical malpractice for a few moments. Much of this material, of course, is in your textbook. I will just be touching on a few highlights as we go forward. We'll talk about the litigation process. We'll talk about some general concepts of medical malpractice so that you're familiar with the terminology. We'll talk about the starting of a lawsuit, discovery, trial, and then we'll kind of put professional liability in the context of the social order and also what it means in the professional context. So let's talk about some general concepts of medical malpractice. The necessary elements of a tort, which torts are, for our conversations, really are personal injuries. Medical malpractice is a type of tort. First is negligence, and these are the elements that a plaintiff must prove. They must prove that the physician deviated from the standard of care, and so they have two parts. They have to first prove what the standard of care was, and secondly, that the physician deviated from the standard of care. They have to prove that there was an injury, that the patient suffered an injury in the case. And third, they have to prove proximate cause. And the example I often use with my students is, if I drive 95 miles an hour down the interstate, that's probably negligent. If a fellow standing downtown has a heart attack, he has injuries. But there is no proximate cause between those two concepts. There is no direct relationship between me driving 95 miles an hour and this fellow having a heart attack. And that often is the downfall of medical malpractice cases, because there is not that connection between an alleged deviation from the standard of care and the injury that eventually occurred. As we discussed in our earlier sections, informed consent is an important component of providing health care, and it is not uncommon for a physician or healthcare entity to find themselves getting sued for failing to obtain informed consent. What is often misunderstood in that concept is, the plaintiff must establish what a reasonable physician would have disclosed in the same or similar circumstances, and that the physician failed to do that, and that a reasonable patient would have not had the surgery or the procedure that was undertaken had they known what a reasonable patient would have expected to know. Just because one fails to disclose an obscure risk doesn't mean that a patient automatically gets to recover damages, because if it is a life and death sort of situation, usually, of course, the patient is going to choose to have the procedure as opposed to die. And so informed consent cases have routinely not been as successful as they have been talked about. I have sometimes referred to them as kind of the Hail Mary pass, that if plaintiff doesn't have anything else, they would argue a lack of informed consent. There are more exotic theories out there. Patients will try to argue conspiracies sometimes, violations of various federal statutes that may or may not apply, or even state statutes such as Consumer Protection Act theories. Those are usually not successful, but plaintiffs are endlessly creative in thinking of new ways of trying to find liability for healthcare providers. The kind of the emerging trends that we see, well, actually, the trends that we're seeing is that the number of medical malpractice cases have dramatically declined over the past decade. Patients do not recover as often as they would think. And the size of those recoveries, when they do occur, sometimes, of course, are eye-poppingly large, but usually are not as large as one would like. Because of tort reform legislations, there are often caps or other limitations on recovery, and it is an endless goal of the healthcare lobbying groups to restrict recoveries even more and more. Let's talk about some of the details of starting a lawsuit. The first step is referred to as a complaint. Some states may use more archaic terms such as a writ or some other terminology. But that is the kind of the initial kickoff. of a lawsuit. That is followed by responsive pleadings that may be an answer, meaning that you simply respond to the allegations that are made. One may file in Virginia what's referred to as a demurra, a uniquely Virginia term in federal court, and in most states have be referred to as a motion to dismiss, meaning that what plaintiff has put in their complaint does not state a cause of action. I mean, even if they proved everything that they alleged, they wouldn't be entitled to recover. A defendant may plead affirmative defenses, such as consent. It may be that the patient caused or contributed to the injury that they suffered, which in a state such as Virginia is a complete bar to recovery. In other places, it may be a partial limitation on the amount of the recovery, what's referred to as comparative negligence. And a responsive pleading might be a special plea. A special plea is, again, like a motion to dismiss in a lot of jurisdictions. The bottom line of that is in essence, the defendant says, I have immunity from this lawsuit, or this lawsuit can't go forward because it may be that the statute of limitations has expired. The patient didn't bring their lawsuit within the time period allowed. It may be that the doctor is a state employee, and because of the care that she was rendering, she is protected by sovereign immunity. Maybe she was a volunteer in a clinic and is covered by a charitable immunity. There may be other reasons to lend protection to the provider. We then move into what's referred to as the discovery stage. The first step of that are interrogatories. These are written questions that are exchanged between the parties. They usually are kind of demographic, for lack of a better term, in that a party will ask name and address of all the fact witnesses, what they have to say or contribute to the case, any statements that or interviews that have been conducted. And usually those will be accompanied with a production request, i.e. asking the opposing party to provide any medical records, employment records, any other evidence that the parties may want to introduce at trial, so that the goal is to lay the cards on the table. This is how we think we can prove our case, or this is how the defendant thinks they will disprove the case. The parties are also entitled to subpoena records and people. Subpoenas, a subpoena ducis tecum is a term of art that, in essence, it is a request for someone to produce a document. In our world, that usually is our medical records, but it may be employment records. It may be investigative records by a government agency, whatever the situation. A subpoena may also be issued for a fact witness to appear and give testimony in a deposition. And in that deposition, the parties have the opportunity to ask questions of a witness about the facts pertinent to this case. All of this may be followed by what are called requests for admission, or requests to admit. And the purpose of requests to admit are to do away with peripheral issues. Admit that these are a true and accurate copy of the medical records. Admit that the person was employed from X date to X date. Admit that there is no issue as to the academic qualification of the defendant, and so on. The next step would be the expert witnesses. Plaintiff has an obligation to designate expert witnesses who will testify that the defendants deviated from the standard of care and proximately caused the injury that is alleged. Likewise, I use the analogy of a tennis game. The defendants have to hit those tennis balls back across the net. They have to find experts who will testify that the defendants did not deviate from the standard of care, that they did not cause the injury that is alleged, or there is no proximate cause. Plaintiff has to prove all three of those propositions, and if defendant is successful, theoretically, of overcoming any one of those, then they should win at trial. Once we get to the trial stage, then there are usual sort of routine steps that occur. The first are what are referred to as motions in limine. As you might gather, we are a guild amongst the lawyers ourselves, and we try to use as much terminology as possible to obscure what we're doing. These are pretrial motions that are usually related to evidentiary matters. We want the judge to keep out a history of alcoholism by a provider that is not pertinent to the issues in the case. The plaintiff wants to keep out a prior conviction that has nothing to do with the case. Those sorts of issues that can be dealt with prior to the trial. The next step would be jury selection. Depending on what venue that you work in, this can be a quick or a slow process. When I practiced in Chicago, it might take us 3-4 weeks to select a jury. Whereas in Virginia, we usually select a jury in 1.5 to 2 hours. I've sometimes joked that I could round up 7 people in the parking lot at Walmart and probably know them just about as well as a Virginia jury. Jury size varies from jurisdiction to jurisdiction. In Illinois, for example, we used a classic 12-juror panel. In Virginia, for civil cases, we use a panel of 7 to try a civil case. Each side is allowed to make opening statements. Plaintiff outlines what they think the evidence is going to show, and then the defendants follow to say what they think the evidence will show in the case. Plaintiff goes first because it's their burden to prove his or her case, and then that is followed by the defendant's case. In most trials, the witnesses don't overlap. Plaintiff goes first to present all of their witnesses. There is a stop, and often there are motions at that point. Defendants will argue that plaintiff failed to get over the very low bar of the amount of evidence required to go forward with the case. That is usually denied, and then the defendant's turn to present their witnesses in the case. At the end of the defendant's case, plaintiff then is entitled to rebuttal evidence, and rebuttal evidence should be limited to any new issues that the defendant has raised in their case in chief that was not covered by the plaintiff. It isn't an opportunity for plaintiff to retry their lawsuit. It is an opportunity for the plaintiff to address any new topics. For example, plaintiff says that the injury was caused by infection. Defendants, their case, talks about the fact that it was not infection, the patient actually died of heart disease. Then the plaintiff would be allowed to call a rebuttal witness to refute the idea that this patient died of heart disease. At the end of all the evidence, the jury will be instructed as to what the law is, and these will come printed on paper. The judge and the attorneys will take a break between the end of the evidence and the beginning of jury instruction to discuss and argue what instruction should be given to the jury. These are statements of what the law is that would apply to this case. So they require some personalization for every case, but most of the instructions are fairly standardized. Those are read to the jury. They also go back to the jury in written form for them to guide their deliberations. Closing arguments then occur after that, and that is where plaintiff goes first to articulate why the defendants are liable to the plaintiff. Defendant then has the opportunity to oppose those arguments, showing why the evidence did not prove that the defendant should be liable. And again, of course, there is the distinction between criminal and civil as far as how much proof there has to be. In a civil case, it only has to be more probable than not that something occurred or that there was a deviation from the standard of care. It is not beyond a reasonable doubt, which is the standard we'd use in criminal cases. Once the defendants finish their closing argument, then the plaintiff has the opportunity to again do a rebuttal argument. That is not solely restricted to rebutting any new information that came up. Quite often plaintiffs just take a free shot to re-argue their case in their rebuttal argument. Then the jury is sent to deliberate. They are given no guidance as to how the group dynamic should work, other than you ought to elect a foreperson. They are not told how to go about analyzing the evidence or how to consider whether the standard of care was met or not met beyond the instructions that are given to them in the law. And many a psychologist and sociologist has made a good living trying to figure out how the jury deliberates and what factors go into that deliberation. The jury will then return a verdict. That verdict is usually a form that they complete, that they find they determine first whether or not the defendant is liable or not. If they find that the defendant is liable, then they determine what the damages are. Quite often a jury wants to do the nice thing and find a defendant not liable but still award damages. That is not permitted. They have to find the defendant liable before they can award any damages. After the jury is dismissed, then the lawyers have the opportunity to argue post-trial motions. Usually that is brought by the loser of the jury verdict as to why the jury verdict should be stricken and judgment should be entered in the favor of the party who lost that. If either party is not happy with the outcome at the trial level, then they can seek appeal. It is in many jurisdictions, including Virginia, appeal is not a matter of right. Not every case is taken up by the appellate court. In Virginia, there's only one level of appeal for a civil case, and that's to the Supreme Court of Virginia. And in that situation, the Supreme Court elects, just like the U.S. Supreme Court does, elects what cases it wants to hear. And so unless a case presents a novel question or presents an issue that the Supreme Court feels needs to be addressed, they may not disturb the jury's verdict in that situation. Let's talk a little bit about what is the impact of professional liability litigation on a healthcare professional. For a physician, and we'll take that as a kind of our example, when an adverse verdict or a settlement occurs against a physician, that immediately requires a report to the National Practitioner Data Bank. That is then picked up by a state board of medicine, who will investigate the case and determine whether or not any further licensure action needs to be addressed. A provider is required, usually on either kind of on the bylaws, either at the time of renewal of credentials, or some bylaws will require at the time of the event, report any outstanding lawsuits, settlements, or verdicts. Likewise, health insurers and HMOs have varying reactions to an adverse verdict or a settlement. Some have had a position that they will automatically knock a physician off of a panel if there is a med mal verdict or a settlement, and then it's up to the provider to appeal to get reinstated. Others take a little more nuanced approach of actually looking at what the claim was before they take an action. But anyway, it has an impact upon the physician when they have, even if the fact that they are sued can have an impact, and particularly when we look at professional liability insurance. In underwriting, which is the process of evaluating what the price should be for professional liability insurance, or whether the physician should be insured at all, in the underwriting process, an insurance company is going to look at how many times has this physician been sued, win or lose, because the cost of defense is substantial. They will certainly look at the specialty that a physician is in, and they will look at the frequency that that profession is sued. They'll look at the size of the verdicts for that professional and for that discipline. And all of that has an impact. And so a physician has a tremendous push to not take a case to trial from an objective business sort of perspective, because the outcomes, as you will see in your reading, is that most physicians win at trial, even though it is a long and tedious process to get there. But the likelihood of any given plaintiff who files a medical malpractice case of actually recovering at trial, a substantial verdict is less than 10%. Depending upon which study you look at, the cost of getting there is not cheap. Taking a medical malpractice case to trial can be anywhere from 100,000 up, depending upon the complexity of the case, the number of experts that are involved, how aggressive each side is in representing their client, and a lot of other factors that go into it. If a case is prepared for trial once and for some reason that trial doesn't go forward and requires preparation again, the price is almost double sometimes getting ready for that trial again. So the cost of insurance is driven by a number of factors, and it is a substantial issue for healthcare providers. That's the end of our conversation about medical malpractice. I invite you to reflect on the issue of whether the medical malpractice scheme in the U.S. is the best approach, and I particularly recommend to you Ivan Illich's thoughts on that. But there are certainly other important issues out there, other important publications out there looking at other national schemes, whether it's Australia or Great Britain or Europe, and as to whether those are better schemes or not better schemes than what we have in the U.S. This good-looking guy again is Rux, hanging out and hoping that you have a great day.